Then I will hear arguments. Ms. Mulligan, I assume that you're arguing that.
I am. Thank you. In short, Your Honor, we are looking at the analysis behind the United States Supreme Court case of Miller v. Alabama, where the Supreme Court looks at the differences between the way that juveniles act and the way that adults act, and also looking at the reasons for punishing them differently that has existed in both case law and statute across the United States. And considering those differences, in our case, we see no difference between a person who is 18 years and 3 weeks old and someone who is under the age of 18, because the time period is so short between when Mr. Savage turned 18 and the time of the incident. There is no reasonable difference between his developmental maturity and the developmental maturity of a juvenile who would have been 3 weeks and 1 day younger than Mr. Savage at the time of the incident. Obviously, if this had happened just 3 weeks and a day before it did, Mr. Savage would not be facing a mandatory life without the possibility of a parole sentence. In fact, that would be illegal. My hope is that the court can see the similarities between the behavior, the limitations to understanding and coping with the world that juveniles face, and the ability for adults to act in similar situations. And in light of those differences, allow Mr. Savage to be sentenced to something other than the mandatory life without the possibility for parole sentence. My understanding of the state of Washington case law is such that I don't know of any cases that have dealt specifically with this issue. I don't know of any statutes that specifically apply to, that have occurred after the decision of Miller v. Alabama to address this concern that we have about people who had just turned 18 at the time of the incident, and making that distinction between their behavior and the behavior of someone who is, in essence, similarly situated. The reason we wanted to include additional information for the court was to flesh out the factual part of this case, or of this motion, to show the court how not only in general that people who have just turned 18 are similar to people who are under 18, but also to show that Mr. Savage specifically at the time of this incident had characteristics that made him more like juvenile defendants than adult defendants, and specifically looking at his ability to learn from mistakes, his ability to control his impulsivity. These are things that are different between juveniles and adults generally, but also specifically with Mr. Savage. And I believe that the two people who we have been attempting to contact should be able to provide some information to the court about their understanding of Mr. Savage's developmental immaturity at the time of this incident. If the court is not willing to grant a continuance to allow us to provide that information to the court, and I suspect that that may be because the court feels restricted by the statutes for mandatory life without the possibility for parole. If that is the case, we would hope that the court would permit us to supplement the record after our sentencing hearing within the next few weeks, assuming that we're able to contact those people and get declarations from them. We would simply ask that the court permit us to submit those declarations for appellate consideration.
State's response?
Thank you, Your Honor. Defense counsel's motion is not grounded in the law as it is, but rather apparently as they wish the law were. The defendant, under the law, is an adult. Therefore, the defendant cases that are cited do not apply. He is not a juvenile under the law, and I ask the court to deny defense counsel's motion. Thank you.
Rebuttal?
I have nothing to add, thank you.
Thank you. And while I can appreciate the defense's position, this is not a case where we have a juvenile who's been convicted of the types of crimes that the Supreme Court has deemed sentences reserved for certain crimes should not be as harsh as it is due to the brain development. The defendant is an adult, and he was an adult at the time of the offense. There's been a bright line drawn by our courts, juvenile, adult. That's not blurred. Roper versus Simmons, that the defense relies upon, was decided in 2005. And that dealt with the abolishment of the death penalty for juveniles. We don't have a juvenile here. We have an adult. Miller v. Alabama declared that it was unconstitutional to impose a mandatory life sentence on a juvenile convicted of homicide crimes. Again, we don't have a juvenile here. We have an adult. And I will point out that the Roper case, Roper versus Simmons, that the defense relies upon was decided in 2005. And the defense did point this court to RCW 9.4A.540, paragraph 3. And I did take a look at that. And I will note that that specific statute that the defense relies upon was actually amended in 2005. One can draw the conclusion that was amended in response to Roper. Yet if you look at RCW 9.94A.540, what I see is that the legislature went through and set forth mandatory minimum terms for very specific crimes. Murder in the first degree, assault in the first degree or assault of a child in the first degree, rape in the first degree, and sexual violent predator escape. And the section that the defense relies upon, 3A, states that Section 1, which outlines the mandatory minimums for those various crimes I just cited, shall not be applied in sentencing of juveniles tried as adults pursuant to RCW 13.04.0301E1. That, again, is not the situation we have here. We don't have a juvenile being tried as an adult. We have an adult being tried as an adult. Moreover, the fact that the legislature set out specific mandatory minimums for certain crimes, they didn't make any exception dealing with juveniles for an aggravated murder in the first degree. And so given the totality of where the case law is, and given the specific facts of this case, the defense's motion to dismiss or motion to, in opposition to the mandatory life sentence is being denied. The court is constrained with what the statute says, the statute under which defining the crime under which Mr. Savage has been convicted states that he will be sentenced without any discretion of the trial court to a mandatory life without possibility of parole. With regard to the request to supplement the record after sentencing, I don't believe I heard any position stated by the prosecuting attorney's office on that matter, and I'd like to hear that position.
Again, Your Honor, this was not brought to our attention until today. Under the circumstances, it seems to me there are other procedural mechanisms available to defense counsel, such as a motion to reconsider. I don't think what they're asking the court is appropriate. Thank you.
Anything further from the defense on that particular issue?
From what I'm hearing from the court, it doesn't seem that a motion to reconsider would be fruitful, and so in an effort to conserve the court's time and resources, it seems like it would make more sense simply to allow us to supplement the records so that the information is contained, although it's my impression that the court feels that it wouldn't be able to consider that anyway in light of the mandatory statute.
Supplementing the record with information that the trial court has not even looked at in reaching its decision, I think is inappropriate. I'm going to deny the motion or the request to allow defense to supplement its record on this particular issue. Let's move on. All right, state's position with regard to the sentencing issue.
Your Honor, I'm sorry, was the court's question on sentencing?
Yes.
We are ready to proceed, Your Honor. This was a remorseless rape and murder, and the defendant deserves and the community benefits from the life sentence mandated by law. I don't have anything to add to that, other than, Your Honor, we would like to give Ms. Sims and Mr. Daly a chance to address the court at the appropriate time.
I believe now would be the appropriate time unless there is an objection from the defense on that.
No, Your Honor.
All right.
Your Honor, the state will call Kaiser Sims.
Ma'am, please step forward. Mr. Sorensen, if I could actually move over just a bit so that Ms. Sims. All right, ma'am. What I need for you to do first is state and spell your name for the record.
Kiasa.
Okay. Last name?
Sims.
Okay. And how do you pronounce that?
Kaisa.
Okay. Kaisa or Ms. Sims, what would you like to tell the court?
I want you to know.
If you could speak up so everyone can hear you. I know that's kind of tough. Take a deep breath. It's okay. Take your time.
I want you to know, Tyler and you took my best friend and my sister, Kimmy, away from me. You have also have taken my love of basketball and track, which I enjoyed with Kimmy. And I miss her. It's hard for me. And in October 18th, I became a Dapper Princess, and I'm devoting that to her this year. And the theme is Ready, Set, Grow. I just want her to have peace and rest in peace. Rest her life.
Thank you, ma'am.
Cecil Daly, Your Honor.
Mr. Daly, what is it you want to tell the court? And again, just as I told Ms. Sims, please take your time. Take a deep breath. I know this is talking in front of a group of people, especially on this kind of subject, is not something we do every day, so please take your time.
Okay. I just want to remind the court that Kimmy had a lot of physical and mental disabilities in her life. Kimmy was born with fetal alcohol syndrome, ADHD, physical and mental delays due to her premature birth. She was a 16-year-old with the mental capacity of a 10-year-old, and Kimmy had an unconditional love for all people, and she also loved dogs. It was something she really liked. anytime Kimmy was out riding her bike when she seen a neighbor working in the yard or walking or playing with her dog or just sitting outside, Kimmy would go out of her way just to say hi and ask to pet their dog if they had a dog there, or if she could just help them with what they were doing. Kimmy was friends with all the kids in the neighborhood, no matter what their age. She made friends everywhere she went, at school, the park, or wherever she was at. Kimmy loved to play basketball and track for the Special Olympics. The last basketball game she played in, they lost the game in the last 2 seconds of the game. They would have won, or at least tied the game. They would have gone to the state championship for the Special Olympics. Kimmy was devastated by that loss. The very next year, after her murder, the team played every game in her honor and was determined to win and go to the championship to honor Kimmy. In the 2010-2011 year, her team went on to the championship game and played that game with all they had. They won the championship, and they all stated that the championship was to honor Kimmy. The Special Olympics honored me with a championship medal made just for Kimmy, along with the gold medal that all the team members received. My life has been completely changed by Kimmy's death. I not only lost my daughter, but I also lost my best friend. I live my life with Kimmy in my mind with everything I do. Now, a very large part of my life has been taken and has left a very big part of me completely empty. I have to learn now how to live my life without Kimmy here with me. Each and every day I am reminded of Kimmy. Kimmy is always on my mind, always thinking of the memories of her and the things that we've done together. I will never get to see Kimmy graduate from high school, learn to drive, or to walk her down the aisle at her wedding. These things in life that a normal child gets to enjoy and will always have the memories to look back on, Kimmy will never get that chance to fulfill her dreams. Kimmy's tragic murder has left me with a question that I will never get an answer to. My life has changed forever. That time that has passed before she had been recovered left her body to decompose to the point that the coroner would not allow me to see her, to identify her body, or even just to say goodbye. They even had to seal the casket to protect her friends, family, and the community from seeing her in that condition. Out of appreciation, the coroner and the funeral home staff wanted people to remember Kimmy as she was. The thought of not knowing for sure, not seeing her in person, will always live with me for the rest of my life. I was robbed of the happiness of seeing Kimmy grow and mature into the person she was meant to be. Through this tragic death, I have created a new law called Endangered Missing Persons Advisory. It's named in honor of Kimmy to enhance the Amber Alert to help protect another family from ever having to go through this tragedy. My hope is that law enforcement will use this to help find and bring a missing person home safe. It has been in effect since May of 2013, and it's working. I want to thank the justice system for bringing forth the right decision in this crime, and to know that at least this person has been taken off the streets and cannot do this to another person. It will never give me closure, but at least the legal system, it has given me a partial closure to the tragedy. And I also want to thank the court system and the jurors and everybody that was involved for the terrific job that they have done to bring it to this point. Thank you.
Thank you, Mr. Gabriel.
Your Honor, we don't have anything further, thank you.
Mr. Tolson and Ms. Monaghan?
Yeah, we don't have anything to add.
Mr. Savage, is there anything you would like to say before the court sets sentence? And let the record reflect that Mr. Savage has shook his head indicating no.
Your Honor, for what it's worth, there is an issue of costs. There's a restitution order that I believe defense has signed off on. We are recommending recoupment to the public defender's office for defense, in this case, of $5,000. A $200 filing fee, $500 is crime victim penalty assessment, and $100 for a DNA sample fee to be collected by the Department of Corrections.
Anything further going to be considered in that?
Yes, Your Honor, only that Mr. Savage was only 18 when this offense occurred. He didn't have a job at that time. He has no income now. He's not going to have any significant income while he is in jail. There's absolutely no way that he can pay the recoupment fee that the state is seeking from the Department of Assigned Counsel. And quite honestly, Your Honor, I think it flies asking defendants to pay recoupment for counsel who are defendants who are indigent, flies in the face of Gideon, and we would ask the court to waive that fee or that recoupment assessment. Regarding restitution, Your Honor, Mr. Savage has signed off on the restitution order. We will hand that. We do not dispute that or the other costs that are associated with the case. Here's the order of restitution.
Would the state like to speak to the issue with regard to recoupment of defense costs?
Your Honor, we're simply asking that the public defender's office be compensated. This defendant will have plenty of time to earn, even at a low level of income, while he's in the Department of Corrections. And we'd ask that he be required to recoup Pierce County for the cost of significant trial defense of at least 2 lawyers throughout the course of this 3-year endeavor. Thank you.
And again, Your Honor, I would note that when they talk about a person's Miranda rights, it says you have the right to an attorney at no expense to you. When they talk about a person's rights at trial, we talk about having a right to an attorney at no expense to them. The fact that the state is seeking to recoup costs for an attorney from a person who is indigent and has no significant means of paying for those costs is a violation of their right to counsel. It's a violation of the spirit, if not the law, letter of the law from Gideon versus Wainwright. I'd ask the court to waive that assessment.
Thank you. Anything further from either side?
Your Honor, I think he's gotten his counsel, so I don't think we're impinging on his right to counsel.
Anything further from the defense?
No, Your Honor.
And as quite evident in this matter, this court has no discretion with regard to the sentence it will be imposing this afternoon. I am imposing the sentence of life without possibility of parole. I believe the community custody, which doesn't make sense to me, is also life, given that it's life without possibility of parole, but just to make sure it does not become an issue, because there, for some reason, is a community custody recommendation in the PSI. We'll go with life. With regard to the legal financial obligations, I am imposing $500 for the crime victims penalty assessment, $100 for the mandatory DNA testing fee, $200 for the court costs. There is no dispute with regard to the restitution, and the court will be signing the order with, after the state signs it, restitution in the amount of $5,750. With regard to the DAC recruitment, there's been a issue raised by the defense that Mr. Savage is indigent. He was indigent at the time he was arrested, I believe, when he had just turned 18. He was still a student. There is a mandatory sentence of life without any possibility of parole. You know, at this point, I can appreciate the state's position that the county should be reimbursed for the cost of counsel because he was represented by two counsel